Thank you. Be seated. We move to phase 2 of the oral argument. Mr. Griffin, are you going to be arguing the evidentiary issues?
I am, Your Honor.
We're ready to hear from you, sir. And good morning.
Good morning. Thank you. Chief Justice Kittredge, members of the court, I'm Jim Griffin. I'm here representing the appellant Alec Murdaugh. This appeal presents 5 fundamental evidentiary errors that individually and cumulatively denied Alec Murdaugh a fair trial. First, the court admitted testimony from a cell phone forensic evidence who confessed that he had never actually done a physical experimentation like the one about which he testified and knew nothing more than anyone else in the courtroom. 2, the court admitted gunshot residue evidence from a blue raincoat, despite the fact that the only connecting witness definitively testified that what she saw was a blue tarp and could not be confused with a rain jacket. 3, the trial court admitted unfairly prejudicial evidence over 6 days regarding financial crimes spanning 6 years, the crimes that were committed by the appellants. 4, the prosecution violated Doyle v. Ohio by repeatedly impeaching Mr. Murdaugh regarding his post-Miranda silence after being arrested on the murder charges. And 5, the court admitted firearms identification testimony based upon unprecedented methodology that the expert himself could not state to any reasonable degree of certainty during the counsel hearing. In the interest of time on that 5th issue, I intend to rely on the briefs unless the court has any questions about that evidence. The evidence in this case did not conclusively prove defendant's guilt such that no other rational conclusion could be reached. Therefore, none of these errors were harmless beyond a reasonable doubt. There were no eyewitnesses to Maggie and Paul's murders. The murder weapons were never found. The forensic evidence does not support Alec's guilt. All crime scene criminologists, experts testified that whoever shot and killed Paul shot him in the head, his brains hit the ceiling, and blood and brain matter would have been on the guns and on the shooter. That was without a doubt. And there was no brain or blood matter found on Alec's person, his clothes, inside his Suburban, inside his home. They checked the bathtubs, nowhere. There were trace amounts of DNA found on Alec's clothing that were consistent with his explanation that he checked them for signs of life. There was minimal GSR, gunshot residue on Alec's, which also was consistent by the SLED's own testimony, consistent with him going back to the house, getting a shotgun for personal protection, and waiting for law enforcement to arrive. Alec Murdaugh's interactions with others after he left the kennels that night and before he returned and called 911 was normal. He talked to his son Buster, he talked to his brother John Marvin, he talked to another lawyer, Chris Wilson, about the case. They all said his demeanor was normal. Visiting his mother, there was nothing out of the ordinary about his demeanor. There's no time of death established. The coroner did a finger test under the armpit. The state relies exclusively on cell phone data inside the phone to establish a time of death, which was unreliable in our opinion. The cell phone data showed at 8:45 p.m. there's a kennel video. And Alec had lied about previously in his interviews about being at the kennel with his family. But there's a kennel video at 8:45. There's nothing on the video that would lead someone to believe that there's a murder about to happen. It portrays a normal family. At 8:49, Paul used his phone for the last time. It had very little battery left on it. At 8:55, there was some action on Maggie's phone. And at 9:06, Maggie's phone registered movement for the last time, some 20 minutes after Alec testified that he left the kennels. We submitted an expert on acoustical testing, and it was uncontradicted that if you're in the house with the door closed and the TV on, air conditioner on, you could not hear gunshots down at the kennels. And then Alec's testimony himself denied killing his wife and son. So this was not an overwhelming evidence case. This was a very close case. And the cell phone and GPS data, frankly, pointed to his innocence, not his guilt, as the as I will explain in a moment. And that brings me to the first issue that I'd like to address, is that the state was allowed to present expert opinion testimony about a test that was done during the middle of trial from a cell phone forensic expert, a deputy from Charleston, who had previously been testified about chain of custody and other issues, that during the weekend after our expert testified, and it's critical to know that Maggie's phone was found on the side of the road about a quarter of a mile down Moselle Road and 15 feet off the side of the road. And when we finally got the GPS data during trial from General Motors and the OnStar data, Alec went by that location doing 42 miles an hour at 9:08 p.m. As I mentioned earlier, Maggie's last phone activity, when orientation change in the phone, was at 9:06. The question is, if Alec had thrown the phone out at 9:08, would it have registered an orientation change? Would there have been anything in the phone to record him tossing the phone out? And the testimony that the defense presented was, Mika Sturgis talked about the rise to wake feature. He did an in-court demonstration. I was gonna bring my phone up here, but if you lift it up, it lights up. All of us have.
What's your theory as to when the phone was tossed out of the window of by someone? What does the timeline show? I take it your argument is that when you toss the phone, at some point it's going to the raise to wake feature will activate. So my question is, on the timeline that we have, and it's extensive. Right. What is your theory as to when the phone was tossed?
So, Justice James, with all due respect, I want to rephrase it. I think that's asking the wrong question.
Okay.
I think the right question is, would the phone turn on and record any sort of activity if Alec threw it out the window at 9:08?
Yeah, I know you say that, but I'm talking about in the timeline that we have and the cell phone extractions that we do have, when was the phone tossed?
Well, the state's, so you could say one explanation, it was tossed at 9:06, because that's when it registered. Or you could say at 9:06, it was down at the kennel. Well, we don't know. Honestly, we don't know. We don't know how it got put on the side of the road. There's no witnesses. But what's so critical to our defense is that at 9:08, when Alec Murdaugh goes by that exact same spot at 42 miles an hour, if he had thrown the phone out the window, what would have happened? And the state says they were just replying to our expert, Mika Sturgis, who said he's not qualified to say whether the light would come on or not, whether it would register anything.
Similar question. I don't think you have to have a theory. That's the state's burden. But when we're looking at your argument that Alec didn't throw the phone out when he drove by because it didn't light up, that raises the question of how it got there. Somebody put it there.
Without no doubt.
And it never lit up. So the point that you're making is it's wrong for the state to be able to prove it might not light up, but to me it looks like it definitely didn't light up, because whoever put it there, unless it was at 9:06, the phone did not light up. So I'm raising the question of whether this even makes any difference.
Well, it makes tremendous difference, because if Alec threw the phone out at 9:08 when he goes by that location, our evidence, not through our cell phone forensic person, but through our accident reconstruction acoustical guy, Mike Sutton, with Accident Reconstruction Institute in Raleigh, North Carolina, says that phone at 42 miles an hour will tumble. And when it tumbles, that raised to wake feature. So we did put in the evidence through two witnesses, both qualified, about what they testified.
I got that, but let's just hypothesize that Alec didn't do it. He didn't have the phone in his hand when he rode by at 9:08. Somebody came along at 9:20, these roving marauders, you call them, or whatever, and they killed the Maggie and Paul, and then they were responsible for getting the phone to where it ended up. Wouldn't the phone have lit up then?
It depends on how it was placed there.
If we don't know whether it would have lit up then, we also don't know whether it would have lit up at 9:08.
Well, here's
That's
what,
why I'm asking why this even makes any difference.
here's what we know at 9:08. Alec car is going by that spot at 42 miles an hour. Did the Marauders go by and pull over?
Maybe.
Were they walking? I mean, we don't know. There is no evidence in the record. What there is evidence in the record is he went by that spot at 42 miles an hour, didn't slow down, didn't speed up, and if he had tossed the phone out, it would have tumbled, and all it has to do is go upright, and the rise to wake feature would come on, and so to combat that, they had a guy sit around the weekend throwing a phone around his office from
But
Friday
you
and Saturday.
cross-examined him very thoroughly, and said, you know, he said he recorded nothing about his experiment. He wasn't an engineer. He didn't know more than anybody else, and he didn't testify to anything you couldn't look up on Google. So what's the harm in that? I mean, your cross-examination seemed to be very effective.
Well, the harm is the expert opinion he was allowed to express that says it was possible that the phone would not illuminate if thrown from a vehicle going 42 miles an hour. The harm was when Mr. Waters gets up in this closing argument and says, Paul Murdaugh got up here and testified as to the issues and to the fact that there's no guarantee, in fact, more likely than not, if the phone is violently thrown or flipped out or whatever, it's going to light up. I mean, that was critical to their defense to address, you know, our exculpatory evidence that we went by there at 42 miles an hour, and if we had tossed the phone out, it would have shown something. If they wanted to test that, they needed to put an expert in a car doing 42 miles an hour, throwing it out the window, and then checking the phone to see what happens, and do it multiple times. But you don't sit around an office as if you're playing cornhole with a beanbag all weekend, and then come to court and say, sometimes it lights up and sometimes it doesn't light up. And therefore, I conclude that, you know, it's more likely than not it wouldn't have lit up if Alec Murdaugh went by there at 42 miles an hour.
This is certainly an unconventional moment at the trial, and, you know, I was reflecting back on 10 years of trying cases, none of which were 6 weeks long, and, you know, in the state's reply, everybody's tired, everybody's ready for the case to go to jury. It's almost like there's this unwritten rule of evidence that at that point in the trial, you can pretty much do whatever you want. But the question is, what did they do? And you're saying, when they stood up to speak to Judge Newman, they said, we got an expert. In their brief, they talk about it simply being an experiment. Judge Newman listens to all this, and he calls it an experiment. He doesn't call it expert testimony. He says, page 6721, he did not provide scientific testimony. He conducted an experiment and told the jury about it. And I'm just wondering, do we really need to go through a 702 analysis here, or should we be talking about the admissibility of an experiment?
Well, I believe this court's opinion in State v. White in 2009 that Justice Kittredge wrote, there's no distinction between, so it's an opinion testimony.
Well, that was an opinion. That was an opinion based on the work of a drug dog.
Right. So, and here we have an opinion testimony that when Alec Murdaugh goes by that location at 42 miles an hour, the light may come on, may not come on. More likely that it won't come on. So that's the opinion testimony. And that is, whether it's scientific or experience, it doesn't matter under the analysis, but it had to be proven to be reliable, and it wasn't.
Mr. Griffin, I'd like for you to address the 404B issue, if you don't mind.
Yes, sir.
Do you believe any of the evidence about the defendant's financial crimes could have been admitted under 404B as motive evidence?
No, not a bit, Your Honor, not as motive evidence.
And I have some questions, I'm sure we all do, for Mr. Waters in terms of the expanse that was allowed under 404B. But what about like Ms. Seckinger's testimony, for example, on the day of the discovery of the theft of the Ferris fees? What about the impending motion to compel hearing in the so-called boat case a few days later that would have arguably exposed the extent of his financial misdeeds? Why wouldn't that have some relevance for 404B motive purposes?
Well, we have the benefit of extensive in-camera hearing, well, not in-camera, but hearing outside the presence of the jury, and where all of these matters were testified to. And Ms. Seckinger said that on June 7th, she went to confront Alec about, this Ferris fee. Now, understand this Ferris fee is a one-off situation from all his other scams and schemes. This was attorney's fees that were due to the law firm that he diverted to himself. That's the Ferris fee. And that's what was their concern, and their testimony was they weren't concerned that he was stealing money from the firm. They were concerned that he was hiding money from civil discovery from the boating case, and they didn't want any part of that. She also says when she's in there talking to him, he gets a phone call. They put his dad back in the hospital, and I took my CFO hat on, and I put my friend hat on, my mama hat on, and I started comforting him, and that was the end of it.
So until the moment of the call about the impending declining health of the father, we're in the motive territory. But once the urgency was removed by that phone call, it somehow's off the table?
I still don't think it's motive, because what the cases cited by the state and any case that you look to, for motive, it has to, and the cases that admit these type evidence in a murder case, is that the person murdered is either the victim, the person murdered is a threat to report the crime, the person murdered life insurance, or the murderer is bound to benefit financially to get himself or herself out of the financial hole. I mean, none of those typical motive issues are present. What was present is this claim of sympathy, which in West Virginia v. McGinnis, and that really is the closest case that we can find about this, Your Honor. I mean, they reversed a murder conviction for letting extensive financial crime evidence and other information in, and I would read to Your Honor the conclusion from the court in the West Virginia Supreme Court. It says, the cumulative admission of the evidence under 404B, however, presents us with a likelihood that the jury convicted the defendant because of his character and not because of the evidence surrounding the murder. In these circumstances, these errors cannot be regarded as harmless. And you can't just piecemeal it either. I mean, we spent 10 witnesses over 6 days, 38 transactions.
Was there any 404B evidence that was proffered by the state that was disallowed?
No, Your Honor, not that I can recall. And then, so you have 404B analysis and you have 403, and really the unfair prejudice just by the weight and the extent of that evidence, the sheer volume, 38 transactions, $9.97 million, 10 separate witnesses. In State v. James, I know it's a little different because State v. James involved prior burglary convictions with an enhancement, but the conviction was reversed where 7 burglary convictions were admitted when they only required 2, and there were limiting instructions given, and the court said that it was not harmless error when you pile on that much, and this was piling on.
Let me ask you a question about the legal point of whether there's a logical connection or some logical relevancy, using the language our cases have used. I mean, you make a lot of good arguments that it makes no sense. Like this, he would never have done it for this reason. And obviously those arguments are in part at least for the jury to iron out, right? I mean, you made them to the jury and that they decide whether this makes sense in terms of a motive. But what I'm asking is, to what extent does the trial judge, when looking at a theory of motive that isn't 100% solid, to what extent does the trial judge analyze the believability, the ultimate usefulness of the theory of motive before admitting the evidence? Just to continue a second, in Lyle, we said that the trial judge has to clearly perceive the connection. Right. In Perry, we of course quoted that, but we also talked about the trial judge using a rigid scrutiny. I mean, really, in Lyle and Perry, though, the question was not the existence of a logical connection, because in Perry there clearly was one. I mean, in Lyle there clearly was one, and in Perry there clearly was not one. At least the majority said so. But in both cases, the real question was unfair prejudice. And I'm just wondering if this idea that the motive theory doesn't work is really a question of unfair prejudice as opposed to a question of logical relevancy.
Well, it's both. You have to do both analysis. Chief Justice Kittredge asked me if it was motive evidence. I don't believe it is motive evidence. It's certainly unfairly prejudicial under 403, and I was, to answer your question, Justice Few, I was about to cite to Lyle, the standard in Lyle, which is a very high standard. And what you have, and I think it should require, and I believe the law makes it require, more than a prosecutor's best theory. I mean, there has to be some evidence to support it, and it has to be like a life insurance policy, a windfall, things of that nature.
Or I hate to use this example, but perhaps this looming cloud, storm cloud, so forth, would have given him motive to do harm to someone who was going to blow the whistle on him, instead of,
That's right.
according to you, too many degrees of separation of murdering his wife and child.
Well, if there was evidence of that, and that's in the case law, yeah, if there were a threat to report, for sure. But none of that exists in
Was there any evidence that Maggie was getting wind of these financial misdeeds? She did have a bounce check or two, right?
Yeah, I believe she perhaps
I mean,
had.
was there any evidence that she
Yes.
was going to confront him about money?
None whatsoever. None whatsoever.
And Paul, who's described as the detective, was there any evidence that he had any information about his financial misdeeds as opposed to him hoarding pills?
No, Your Honor. It was only his drug use Paul was aware of.
I want to branch off for a moment. On page 6,340 of the record, Mr. Waters was cross-examining Mr. Murdaugh. And if you read it, it is very, very compelling cross-examination. Of course, Mr. Murdaugh's on the stand, so his credibility is in question. Let's assume that this financial crimes evidence came in reply.
Right.
Because a series of questions that Mr. Waters asked Mr. Murdaugh was, you lie, basically suggesting he lies with ease.
Correct.
Seamlessly lies about everything. Did you lie to your brothers? Did you lie to their wives? Did you lie to Marion Proctor? Did you lie to Bart Proctor? And all these answers were yes. Did you lie to the Brandstetters? Did you lie to Chris Wilson? Did you lie to them about the kennels? Did you lie to Mark Ball? So when his credibility comes into question then,
Right.
could this financial evidence have come in reply? I know that's not what we have here, but doesn't it kind of open the door, or maybe you would have chosen not to put him on the stand had the financial stuff not come in initially?
Well, there are 2 points with that. One, I don't think we cited case law that we don't waive our right to challenge that by putting him on the stand
I
to
get
address
that.
it.
I get that.
But to answer your question specifically, under 608B, Your Honor, you are not permitted to put in extrinsic evidence of these things. You can ask him about it, but you can't then take 6 days and 10 witnesses. I mean, you ask him the question, and if he answers it, you got it. If he denies it, you're stuck with it. That's what under 608B. You're allowed to cross-examine him, but you're not allowed to introduce extrinsic evidence.
What if the questions had been more expansive? Did you lie to your partners about not stealing $9.7 million? I mean, it becomes, it's a different dynamic, I understand, but what I'm trying to search for is, would this have come in anyway?
Well, I do believe under 608, it's fair ground for cross-examination on his credibility. But then you get the 403
with his
analysis.
answer.
Excuse me?
You're stuck with his answer, which would have been
Right.
yes.
Yeah, but you don't get to then start putting up 10 witnesses to prove something that he's admitted to.
You get a new trial is coming in, but it's only, at least under 608,
If he testifies.
if he testifies. And in that event, you get another limiting instruction that says you can only use this to analyze his credibility.
Correct. Thank you.
I think it's
Oh,
Wait a minute, we're just getting started.
About the weapons? Yeah. We have a question. We want you to argue about the admissibility of the weapons that were seized and introduced that were from Moselle.
yeah, so, in the weapons that were introduced in the evidence that were seized from the home, there was no, testimony from anybody, even their
Well, it's beyond that. The experts admitted that he could not identify it as a murder weapon.
Well, he said he couldn't include them or exclude them. And so, as we said, these guns, we know nothing more about them today than we did, any other day. Yet they were allowed to put those in the evidence. And we've got State v. McConnell and another case where I think McConnell, where they put .22 caliber bullets in evidence on a shooting case. And the person was shot and killed with a .357 Magnum. And that case was reversed. There was another case that we also cited, lost my place in my notes, but that.
What was the purpose, as you understand it, for the admission of the weapons that were seized from Moselle?
To prejudice Alec Murdaugh. I mean, that was the purpose. It made nothing more relevant or not relevant. I mean,
Didn't you suggest, though, that the police who investigated this had failed to do a complete job, and in particular, that they had failed to properly seek out and find the murder weapons?
absolutely, and that stands
And
true
wouldn't
today.
simply, wouldn't a simple response to that suggestion be, we looked at every 12 gauge and 300 blackout weapon on the property, and here 4 of them?
Here's pictures of 4 of them, but you don't put them into evidence. You can have Greer testify, I tested all these guns. I don't know anything more about them today than I did yesterday. I can't include them or exclude them. That testimony is perfectly appropriate. But
After they were put into evidence, were they ever used or referenced again, touched again?
Absolutely, the Attorney General picks it up, holds it up, pretends that he's shooting somebody. He picks up the 300 blackout and reenacts the crime. Mr. Kinsey used them.
Well, they can be used for demonstrative purposes. You just object to them going back into the jury room. Is that what you're saying?
We did object to them going into evidence, for sure. And they could have had a demonstrative, demonstrative exhibit to demonstrate to the jury, but that's not what these were. These went into the jury, and they did an in-court reenactment with them.
Mr. Griffin, I interrupted you a little while ago to segue to the 404B issue, and I think you were either at or near the conclusion of your argument regarding the cell phone experiment.
Right.
And if I cut you off, I didn't mean to, and I want to give you an opportunity if you want to finish any thoughts you had on that issue. It seemed very important to you, and I want to give you that opportunity.
I was done with the cell phone. I was going to go to the blue tarp and then the Doyle v. Ohio issues, but I'll rely upon the briefs, and Mr. Barber may be able to address it on reply. But I'm happy to stand up here and answer any questions about those issues.
I got a question about the cell phone.
We have a question.
Help me out here. The evidence was Mr. Murdaugh didn't use his phone from 8:09 to 8:40 something, 8:50, maybe 9 o'clock, right?
Right.
Which was unusual for him, according to the evidence. What does it mean in the testimony of the cell phone extraction witness when a call was in the Verizon records but not on Mr. Murdaugh's extraction? What does that mean? There's a series, I made a series of notes. This call was not on his extraction. It was on Maggie Murdaugh's extraction, but not his. 905 calls Randolph, not on extraction. Does that mean that the inference is that he physically deleted it on his phone?
I believe so.
And there were probably 10 or 12 or more phone calls that were deleted, if
Right.
that's what the explanation is about not on his extraction.
I believe that is the case, that the information was deleted from his phone for some reason or another.
And this goes to circumstantial evidence of something, that he deleted the call. Was there any explanation at trial from your side, not that you were required to give one, as to why those calls weren't on his extraction?
There's no testimony about that at trial.
Okay, all right.
I have thoughts about that, but it's not in the record.
All right.
Justice Hill has a question.
Maggie's phone did not record steps at the
Right.
time, and you make a point about that.
Yep.
But you also, the location data got overridden. Did that override the step data too?
That did not override the step data.
Okay.
And that was maintained in a different place, but the GPS data is pinging constantly, and there's only so much room, and SLED did not put that phone in a Faraday bag, which I didn't know what a Faraday bag was before this case, but they give them away at conferences, so it's not unique.
Thank you.
All right, no further questions.
Thank
Thank you so much, Mr. Griffin, appreciate it.